the accused person was, fortunately, he was in Shillong because of his other committed works, Lordship. Later, Lordship, RTO Assam has called him on 27, that is tomorrow, Lordship, and for which we need interim protection, Lordship, because if we go to RTO to comply with the RTO's order and everything, but if there the police might arrest me, Lordship. Now on in page number 10 and page number 11, Lordship, I have already signed 2930 form, and also, Lordship, on perusal of the RC which has been retained by the IO, I could not produce this. On perusal of the RC, which is a genuine document showed by the seller, I signed this 2930 form, Lordship, on good faith, Lordship, and consideration amount of 1,50,000 was already paid to the buyer, to the seller, Lordship. Lordship, my requisite documents has already been produced to RTO and for the sale process. Now the RC is already in my name, Lordship. RC is transferred in my name, but police on, I don't know where from the FIR received by police, RTO on proper verification of the document has transferred in my name, but I don't know from where police has received the FIR, a copy of the FIR, and police received a FIR and lodged a case against me. Now I am in a very dilemma that, Lordship, if RTO calls me on 2706, that is tomorrow, if I go and appear before RTO, Lordship, I'll be subsequently arrested. This is my presumption, Lordship, because on repeated request that to issue 35 notice under 35(3), Lordship, to protect me, to cooperate with the investigating agency, because this is a below 7 years, I have not been provided with 35(3) notice, Lordship.
Where is the FIR?
A copy of the FIR police has not provided on repeated request also.
Which police station?
No, Barneyhat police station, but the case is registered as Nongpo PS. Nongpo PS case number 66 of 2024.
Yes, Mr.
A minute, pieces, Your Lordship. Lordship, the admitted fact is that it's a 379, Your Lordship. 379, so the punishment is below 7 years, Your Lordship. So by virtue of Anish Kumar case, Your Lordship, notice will have to go, Your Lordship. So my the apprehension of the accused, Your Lordship, in my humble and respectful submission, Your Lordship, it's not a reasonable apprehension, Your Lordship. Because police cannot arrest, Your Lordship. They'll have first to issue notice now under the BNSS, Your Lordship, section 35(3), Your Lordship. So the question of arrest does not arise, Your Lordship. Then another aspect of the matter, Lordship, kindly come to page 8, Annexure 2.
Yes.
Can you see the sale transaction, Your Lordship? The sale transaction, Your Lordship, the money has been paid to one Dikshita Bora, Your Lordship.
Yes.
Dikshita Bora. Then, Lordship, kindly see the form 2930, Your Lordship. The form 2930 is signed by another person.
Where is the form? Page?
Page 10, page 11, Your Lordship. Lordship, the signatory to that form 2930, Your Lordship, is by another person, Your Lordship. And Lordship, kindly come also to page 12. Page 12 also by the same person, Your Lordship. Lordship, if the this is also blank, Your Lordship. Kindly have a look, Your Lordship, at page 10, page 11 is all blank. Then even at page 2 also all blank, Your Lordship. Only the signature is there, Your Lordship.
Lordship, these documents are produced before RTO, Lordship, and that is why, Lordship, RTO has called on 27, that is tomorrow, Lordship.
If the person who signed Form 2930 is the owner of the vehicle, why should the money be transacted be paid to another person, Your Lordship. Something wrong, Your Lordship. It might be a stolen vehicle also, Your Lordship. We do not know, Your Lordship. It might be a stolen vehicle, Your Lordship. Because now it's rampant, Your Lordship. Vehicle theft, Your Lordship, now is very rampant, Your Lordship.
Lordship,
And the fact, Your Lordship, that Section 379 of the IPC, Your Lordship, because this is a pre-July 2024, Your Lordship, so it is under the old IPC, Your Lordship. As I have submitted earlier, it's below 7 years, Your Lordship. The question of arrest, their apprehension of the petitioner is not reasonable, Your Lordship, because police cannot go against the guideline issued by the Honorable Supreme Court in Anish Kumar case.
Lordship, police visited on 20th June, Lordship. Police visited my residence, Lordship. But since I was not aware that I was in Shillong, Lordship.
Whatever the case may be, they may have visited you, they may want to question you, but the fact remains that it's mandatory that notice has to be issued.
Lordship, it is mandatory, Lordship. I should have, yes, Lordship, I should have received. Lordship, the fact remains that, Lordship, I should have received for notice under Section 35(3), Lordship. By any way, Lordship, by now WhatsApp is also, Supreme Court has provided through WhatsApp notice, service of notice is also accepted by the court. So by WhatsApp messages also, through which police is contacting me, could have issued 35(3). I just need a interim protection so that I can cooperate with the investigating agency, Lordship. Since 35(3) is not issued against me, Lordship, I am under still impression that I may be arrested, because it is a case from July, prior to July, Lordship, that is under old Act, Lordship. It is 60/06/2024, Lordship. So it is 6 means prior to June, in the month of June, Lordship. So I need an interim protection so that I can cooperate with the investigating agency, Lordship.
Heard Ms. Counsel for the petitioner, who has submitted that the petitioner has purchased a vehicle bearing number AS01 FX 5955 on 10 June 2024. What is the name of the seller?
The name of the Prasurya Neel Kalita.
Prasurya Neel
Kalita.
Kalita. In compliance with the relevant provision of law under the Motor Vehicle Act, the petitioner has also In this form 2930, your signature is not required.
It should be, Your Lordship.
Transferor. Where is transferee?
Lordship, kindly have a look at page 10.
Yes.
Kindly, Your Lordship, see to the left. Because I cannot be read, Your Lordship. It's not legible also. Signature, Lordship, is
This is financial. Transferor.
Signature of the
See, is this form and whether it's complete? Whether you can call it a contract.
it's a blank. It's a blank form, Your Lordship.
But there must be some
It's all blank.
blank, no doubt.
Even at page 12 also, Your Lordship, blank.
But where is the provision for signature of the transferee? Okay. Untuk kau? Has the petitioner also has received copies of the form 2930 under the relevant rules of the under the Motor Vehicles Act, wherein the transferor, public seller of the vehicle has penned his signature. It is the submission of the learned counsel for the petitioner that the petitioner came to know that an investigation was launched in connection with the said vehicle, meaning that there is suspicion that the said vehicle is a stolen vehicle. However, the Land Council has submitted that no intimation was received by the petitioner in as much as the nature of the offence would attract the provision of section 379 IPC, public theft. The punishment for commission of such an offence being below, is it 7 years or below?
below 7 years.
Below 7 years. Yeah.
Below 7 years. It is the further contention, submission of the learned counsel for the petitioner that notice under section 35(3) of the BNSS ought to have been issued upon him, but was not done so. As such, there is apprehension that he may be arrested at any point of time in connection with the said transaction. again, the learned counsel has submitted that the petitioner has been summoned by the RTO, what district? Kamrup district, Assam, on 27/6 to clarify the matter. However, because of the apprehension of arrest, the learned counsel has submitted that this petition is accordingly moved before this court with prayer for grant of pre-arrest bail. And in the meantime, prayer for interim bail is also made herein. Mr. NDPS learned AAG, appearing for the state respondent, has at the outset challenged the maintainability of this petition on the ground that the contents of this petition, including the annexed thereto, would reveal that if any offence exists, it would be one under section 379 IPC, which, as the learned counsel for the petitioner has submitted, would entail that the investigating officer would entail that the investigating officer issue and a cost to be issue a notice under section 35(3). Non-issuance or non-receipt of the same by the petitioner would only goes to show that there is no intention of arrest by the investigating authorities. And even if such notice has been issued, still then the petitioner would not be arrested at the first instance. Accordingly, since there is no reasonable apprehension made out, this petition is liable to be dismissed as devoid of merits. Further submits the learned AAG. This court has considered the submission made by the respective counsels for the parties and is made to understand that the cause of action which prompted the petitioner to approach this court relates to a sale transaction of the said vehicle, which after such transaction have been completed, came to the knowledge of the petitioner that the said vehicle may have been a stolen vehicle, for which those who are involved in such transaction, including the petitioner, are liable to be prosecuted under the relevant provision of law. Accordingly, apprehending arrest, the petitioner has approach this court with this instant petition. At this point of time, there is no materials on record to indicate that, firstly, any FIR has been filed in this regard. Secondly, whether the IO has issued the statutory notice under section 35(3) BNSS upon the petitioner. The fact remains that without any reasonable apprehension, the petitioner would not have approached this court. Since crucial details are not available with this court as regard registration of any case or prosecution or investigation launch, therefore this court is in agreement with the submission of the learned AAG that no ground is made out for pray for grant of pre-arrest bail. Accordingly, this petition is hereby dismissed. Before parting, this court would opine that under the facts and circumstances as has been related by the petitioner, since no notice under section 35(3) has been BNSS has been issued upon him, it can be presumed that he is not to be arrested. In such a situation, it would be but natural for the petitioner to be convinced that unless the process relating to the issuance of a notice under section 35(3) is exhausted, there is no reason why he should be arrested. Petition disposed of. You get a copy of this order. If anybody comes to you, you show it to him.
Obla, Your Lordship.
Item number 2.
Otherwise, Your Lordship, he will be facing a contempt if he arrests him, Your Lordship, without issuing that notice, Your Lordship.
That is why you have no case, because as Mr. Shulai said, there is no apprehension. But I'm just safeguarding your interest.
Lordship.
If you are to be arrested, as Mr. Shulai said, process they have to issue you notice.
Lordship.
All right.
Yeah.
Good morning, Your Lordship.
Yes.
Your Lordship, I would crave your leave to withdraw this petition and with the permission to file afresh. I've made some mistakes in drafting the same, and certain wrong documents have been annexed onto the petition. You can file it afresh, Your Lordship.
Mr. Associate, learned counsel for the petitioner has submitted that on being instructed, the petitioner may be allowed to withdraw this petition with liberty to file a fresh one, if so advised. Accordingly, petition stands dismissed as withdrawn with liberty sought for allowed.
Thank you.
Item number
This
3.
is for both.
No, this item number 2, Your Lordship.
Number 2.
Supplementary list item number 2. The bail matters from yesterday are listed at number 4 and 5.
Okay.
That's a new matter.
Oh, this is a new.
New.
This is an unlawful activity.
Oh, okay.
Item number 3.
Bless you. 2 and 5.
Itu dah. This one. Satu.
Now, should these bail applications flow from yesterday?
Yes.
So during the course of the hearing yesterday, Your Lordship, I was directed to file orders and status reports from the trial court to ascertain whether delay, if any, if it has been caused at all. If the causation is because of the defense counsel. So, Your Lordship, yesterday I filed an affidavit. I have annexed orders and status reports also from, which are downloaded from the e-court site. So I'll just take Your Honor's attention to the respective orders. If Your Honor finds the affidavit. Anyone would do, Your Lordship. It's the same. I file affidavit in both the cases, same context, of course.
Yes, yes.
So, Your Lordship, I've annexed 8 orders, wherein the status would come into picture as to what the status of the case is and whether delay has been caused or not. I would like to take Your Honor's attention to page number 6 of the affidavit, just annexure 1. Right, Your Lordship. So, I had also pleaded yesterday the last witness, PW1, was examined on the 6th of March 2025. And this order is a testament to that fact. The operating part, of course, would be the second last paragraph, Your Lordship. PW1, Shri Kosan B. Marak is present, examiner-in-chief, defense counsel, and thereafter the witness is discharged. Thereafter, Your Lordship, after the 6th of March, all the subsequent orders will show that no witnesses were examined thereafter. I'll take you to annexure 2, Your Lordship. Annexure 2, again, the third last paragraph, witness Shri Dorshai Kirsan is present. However, his evidence could not be recorded as the prosecutor is not ready to record the evidence of the said witness. Fix 4th of April for production and evidence. Then we go to the 4th of April, of course, Your Lordship. 4th of April, again, Your Honor will find again the 4th last paragraph. No witness is present today. Thereafter, Your Lordship, the matter was fixed on the 17th of April. I'm sorry I couldn't get an order of the particular date, but business reports are available on the e-court's website, which I've annexed as annexure 4. These also show the status of the case, Your Lordship. So annexure 4 is the order, is the status of the case from the 17th of April. And it says, matter could not be taken up as the presiding officer is on leave. Thereafter, 1st of May 2025, Your Lordship, next date for production and evidence. This date as well the witness had not appeared. There was no evidence. Thereafter, Your Lordship, there's an order dated 16/5/2025, and Your Lordship will find again in the 4th last paragraph, no witness was present on that day either. I was present though. I've been present throughout. And thereafter, Your Lordship, the matter was fixed on the 30th of May 2025. Again, the status report is available, which says presiding officer was not available on the particular day. Thereafter, the matter was fixed on the 13th of June 2025, Your Lordship. The status report is annexed as annexure 8. And as you can see from the business portion of that particular status report, Your Lordship, the accused persons on that particular day were remanded before the CGM court. Now, that is because the PO was on leave on that day as well. That is why the production happened before the CGM court. And Your Lordship, the next day, which is fixed on the 27th of June, is again only for the appearance of the accused, not for evidence.
How many witnesses you say?
There are a total number of 10 witnesses, Your Lordship. I'll just refresh a few points from yesterday, Your Lordship. So, what had happened, Your Lordship? I had pleaded yesterday that the charges were framed on the 17th of December 2024. Thereafter, 6 months.
Let me note down.
Yes, Your Lordship.
17 December,
2024, the charges were framed.
charges framed.
Yes, Your Lordship. After that, it took the prosecution, it took 3 months for the witness to come, who was finally examined, the first witness, and the only witness was examined on the 6th of March 2025. And thereafter, Your Lordship, after a quarter of a year having been passed, being passed, till date, after 3 months and 20 days, no witness has been examined till date. And of course, the orders which I have read in the status reports which I have read, Your Lordship, would actually go to show that the delay cannot be attributed to the fault of the accused or the defense counsel. Of course, we are not here to point fingers, but delay has certainly been caused, Your Lordship. And citing the orders which I cited yesterday, I humbly pray for bail to be granted to these two individuals.
Yes, sir.
My lord, I've gone through this, my lord, this document, my lord. But here, my lord, before I wind up, my lord, I beg to point out, my lord, this is a case. Firstly, huge quantity of heroin, my lord. Secondly, my lord, it is charge sheeted only in the month of December, my lord.
No, sir. Charge sheeted December 2023.
23.
2 years back.
23.
23. Charge sheeted 14th December 2023. Sir, the charge sheet.
No,
Petition is yes, sir. Charge sheet ka date idhar hai, sir.
14 December.
2023. Charges framed 17 December 24.
Almost 1 year.
Yes.
Anyway, yes.
So, my lord, in all the judgments cited, my lord, there are cases of, my lord, delay of 2 years or more, my lord. So, therefore, my lord, I still have objection in this case, my lord, for grant of bail, my lord.
Commercial quantity.
Yes, my lord, it's nearly 800 gram, my lord.
Lordship, even if that is the case, the embargo under 37 would apply. And the orders which I cited yesterday all involve matters of commercial quantity, of course.
Anyway, you see, your ground is only on delay,
Absolutely.
not on whether, you see, Section 37 is applicable or not. Because you would accept that since it involves commercial quantity, then Section 34 is subtracted. Section 37 is subtracted.
Because I'm just only saying this, Your Lordship, because the orders which I cited yesterday have covered that aspect as well. So just speaking on that particular aspect. Yes, sir.
Heard Mr. S.S. Sera, learned counsel for the petitioner, who has submitted that on an FIR being lodged on 1/7/2023, the same being registered as NDPS case number 21/7/2023 under section 21 under bracket C and 29 of the NDPS Act. The petitioner being accused of petitioner was accused of being involved in the said case, was placed under arrest and was placed under arrest on 1/7/2023.
Yes.
And is now in, and is until date is now in custody in the district prison and correctional home, Nongpo. Nowadays you don't write district jail anymore.
Sorry, apologies, I understand. Correctional facilities.
It is also the submission of the learned counsel that the IO, that the investigating officer, on completion of investigation, has filed the charge sheet before the court on 14/12/2023. The competent court of jurisdiction, having taken cognizance of the case, a case was registered as, what's the case number?
NDPS 23 of 2023.
NDPS
Case number 23.
number 23 of
2023.
2023.
3.
2023.
Yes.
2023. and the same is tried by the learned Special Judge NDPS Nongpo
Nongpo, Your Lordship.
Nongpo Ivory District. However, the Land Council would submit that since the charges are on to charges frame,
Yes, already.
tentu charge sheet ni, charge sheet file on
14/12/23.
14/12 ni. Entah, yang tu pulih yang tu hadis sepok tu, nah hadis tu. Saya cuba tu. The court, the learned special judge has then framed these charges against the accused and other co-accused person in this case on 17/12/2024 under the relevant provision of the NDPS Act. Next, the Learned Counsel for the petitioner has further submitted that after the charges were framed, with 10 listed witnesses, prosecution witnesses, the first witness was examined on 6/3/2025, and since then no other witnesses have been examined in the case. The Learned Counsel would stress on the point that since the date of his arrest, that is on 1/7/2023, till date, the accused person has been languishing in judicial custody for more than 2 years.
Almost 2 years, barring 6 days.
Almost 2 years, barring 6 days. Therefore, at this point of time, the only ground that would be pressed on, but that would be pressed by the petitioner for grant of bail is on the ground of delay. To this extent, the Learned Counsel has cited the case of, what is the first case you have cited?
Sujit Kumar Rai.
Cited the case of
Sujit Kumar Rai and Dilu Joy Riang.
just so,
Yes, sir.
Sujit Kumar Rai, wherein in BA number 5 of 2025, by order dated 11/3/2025, this court, being convinced that the trial in the case therein was delayed, has granted bail to the accused person therein. Similarly, in the case of Sanju Singh, Shri Sanju Singh, this court, by order dated 11/3/2025 in BA number 13 of 2025, has also considered the case of the petitioner therein, and again on the ground of delay in the proceedings before the trial court, has granted bail to the accused person therein. I think this case is not required to be cited.
Right.
It's Vicky Kumar.
All right.
Because practically what was relied upon here is the Learned Council has sought to bring parity to the case of the case cited with that of the case of the petitioner herein, has made a prayer that the accused person in question may be allowed to be enlarged on bail with any condition to be imposed by this court. Next, per contra, Mr. Argun Leonard J has strongly opposed the prayer made by the petitioner, particularly on the ground of delay in trial. It is the submission of the Learned J that there has been no delay as far as the proceedings before the trial court is concerned, inasmuch as the charges having been framed in the month of December 2024, one witness was examined, and from the record of proceedings before the trial court, which was from the relevant records which was produced before this court today, it would appear that there was no inordinate delay or unnecessary delay or even willful delay made by the prosecution for examination of the witnesses, but for the reasons stated in the orders of the trial court on each and every date whenever the case of the accused is fixed. The J has also sought to distinguish the case cited by the relied upon by the Learned Counsel for the petitioner to say that in those cases cited, charges have not yet been framed and the proceedings have indeed been delayed, which would justify enlargement of the accused therein on bail on ground of delay. But this is not the case herein. Next, it is therefore great that this application, being devoid of merit, may be Dismiss. This court has duly considered the submission made by the legal counsel for the parties in due perspective. It is made from the records. What is apparent is that a case involving offences under the NDPS Act is ongoing. Reportedly, the case involved seizure of certain contraband substance of commercial quantity. Therefore, Section 21 (C) of the NDPS Act being invoked. It is true that the accused person has been in custody for almost 2 years. But what would be material for this court to consider is whether there has been any inordinate or unnecessary delay caused by the prosecution or the trial court for that matter. On the face of it, a perusal of the orders of the trial court dated 6/3/2025 This is the first order.
Your Lordship. Yes, Your Lordship. That's the first order which I finished, showing that PW1 was examined in that particular.
6/3/2025 would reveal that one witness, that is PW1, was examined and cross-examined and thereafter was discharged. The subsequent orders passed on 21/3/2025, 4/4/2025, 17/4/2025, 1/5/2025 and 16/5/2025, 35/2025 and 13/6/2025. Observed as a whole would show that on some dates witnesses were not present in court. Certain dates the presiding officer is on leave, was on leave. Nothing is noted to indicate that there was any lapse on the part of the prosecution to take steps in the matter. Accordingly, it cannot be said that the trial has been delayed unnecessarily. This being the case, this court is convinced that the petitioner has not been able to make out a case for
Lordship,
grant of bail on account of delay in proceedings.
Lodge. Lordship, there was the one particular order in which the prosecution witness was present, of course, but he was asked to go back since the prosecutor was not ready.
Those are routine matters. It happens. There are 10 witnesses. 9 witnesses. See, if you can convince the trial court to summon as many witnesses as possible, within the next 2-3 months it will be over. If not, after 2-3 months you come before this court again. Last line. The authorities cited, with due respect, are not deemed not to be applicable to the peculiar facts and circumstances of this case. This petition is accordingly disposed of, is dismissed as devoid of merit, seems disposed of.
Declare.
Daily list, item number 1.
Mr. Paul,
Well,
how long will you take?
this matter will take some time.
5 minutes. 5 minutes.
Well, I can give the gist in 5 minutes.
I'm looking at the time.
Division bench.
What do you do, Mr. Bhanta?
You can start it if Lordship no inconvenience caused.
You are the elder here, so we'll have to respect your.
This is that matter concerning customs, Millet, so we'll have to go into the law. This would require a bit of time.
But if it goes into a custom, those are disputed question of facts. Writ court cannot go into that.
No, whatever the case may
I
be.
don't let him
That
submit.
would be
Let him submit.
We'll fix it next week then. Next week?
next week, no?
Or you can suggest a date. Any date that is convenient to the parties.
Can it be on 3rd, 4th like that? Anything?
3rd, 4th is okay with me.
Wait, like that, no. Hearing? Yeah, bro. South Korea? Kanong khara? Okay, come on. 4th.
4th, Millet.
4th.
As agreed to by the parties, list this matter for.
Well, it's just one issue that I had to flag. my lords will take it up on the 4th. There was an order passed on 5/12/2024 by this Honorable Court. My lords, the state was to place instructions before this court regarding, my lords, whether they were willing to take over that road. That instruction is yet to come by, my lords.
At the time of argument, your lordship will.
Because there's a direction, my lords. If I may read, in consideration of the submissions of the parties, no orders are necessary at this stage, but it is directed.
Yes, you're reading.
Well, this is the order dated 5/12/2024. My lords have it, my lords. The last paragraph, my lords, page 2.
512.
5-4. It's in miss case number, my lords, 164 of 2024. I don't know if it's there in the main order sheet.
Oh, in this case.
Miss case, my lords. Miss case number 164 of 2024.
Just read out.
Well, it's in the
Is it a
consideration.
long order or short?
Short, my lords, just 4 lines. In consideration of the submission made of the parties, no orders are necessary at this stage, but it is directed that the state respondents to conduct the survey of the road as to whether it is feasible for them to take over the same to effect repairs so that trade and commerce will not be affected.
Yes,
That has not come.
Mr. Shulai, why?
Lordship, it has been done, but we are not inclined to take over, your lordship.
No, for repairs.
Whatever the case may be, you see, you're called upon by the court to file a report.
I think the report is here, your lordship.
It was filed.
Yeah, yeah.
No, that is our
Please, your lordship, on the next.
They have not filed a formal report, my lords.
Whatever the decision would be, would that have a bearing on the?
Well, insofar as repairs are concerned, yes. Larger legal issue may not be, but repairs are concerned, that will be yes.
That belongs to the CM's road. Therefore, state, not PWD, they are not looking after that.
That's their case, my lords.
Because, your lordship, what happened, your lordship, this is a bridle pan. It's a bridle pan. It falls within the jurisdiction of the scheme of SORA, your lordship.
No, true. Whatever the case may be.
I'm aware of that, lordship. I'm aware.
You should have filed it.
I'm aware of that.
You see,
order.
what is called upon you is to make a survey. Number one. Number two, to find out if it can be repaired or not. Number three is if it is to be repaired by you, or maintained by you, or taken over by you. That has to be,
That is to come before this court.
Lordship,
Then we'll do one thing. Can you file it by Monday?
lordship, it may not be possible.
Let it be on the
It will
court.
come after 2 weeks, then, your lordship.
Well, may I pray, let the matter start. We can start with the main matter on the 4th. And in the meantime, my lords, they can file it.
That also can be.
They can file it in the meantime, my lords, because I don't think we'll be able to conclude in one day,
No, but the
in all
point-
fairness.
But the point is, you see, whatever has been directed has to be complied with.
My
Number
lords,
one,
my lords,
irrelevant or relevant, it has to be on the court.
my lords.
Number two.
Individual, they can file it.
Number three is, if we start with the hearing and then this report comes
Yes.
and some parties object to it or take recourse to it, then what do we do?
Because what happened, your lordship, we have filed a number of affidavit also, your lordship. It must be. I'll go through, your lordship.
Please.
No, India state affidavit, they had said it is a CM's road. I have the
No,
copy.
that is prior to this order. my
prior
lords.
to that
lot
order.
of water has flown post that affidavit. There's an inquiry report. There are a lot of things that have happened after that.
I mean, they have drawn the map, everything is there. in the record.
That was at the initial stage. After that, a lot of water has flown after that.
Please file
Lordship, send me, I'll look into your lordship.
in which miss case?
Well, this is in miss case
164.
164 minutes.
How to miss case mo? I took a.
The last paragraph, my lords, Meghalaya.
This court, by the order dated 5/12/2024, had directed the state respondents to conduct the survey of the road as to whether it is feasible for them to take over the same to effect repairs. It is incumbent upon the state respondent, on being so directed, to file a compliance report. Mr. Indishwar and EAG has fairly submitted that through inadvertence the said report has not yet been filed. It is prayed that sometime may be allowed for the report to be filed. As prayed for, seems allowed. Place this matter up to 1 week.
Apply.
Much.
Matter will now come on the 4th, my lords.
It will come on the
Well, come after, let's come after 10 days, your lordship. Sufficient time. After 10 days, your lordship. Not
2
after
weeks.
2 weeks. Apply, your lord.
Apply.
To come in case on as agreed to by the parties, listen matter after 2 weeks.
Obliged.
From supplementary 1, item number 1.
Lordship.
You are the National Highway.
Lordship.
Then, delay.
Lordship. One is on delay and the other one is on execution, Lordship. Today it is fixed for orders on execution, Lordship. One miscellaneous application is also there, Lordship.
Execution of what? Of the award?
Execution of the order passed by Special Judicial Officer.
What was the order passed?
Orders passed, the common judgment and order was passed, Lordship.
Was that the order under challenge?
Order was not under challenge, Lordship. Actually, Lordship, what happened on when the analogous matter was on board for hearing, Lordship, that time it came to light that the judgment was passed without pursuing the award, or the award was not enclosed along with the reference case in the trial court, Lordship. So on pursuing the records, on thorough checking of the records, it was revealed that neither of the cases the copy of the award was there, Lordship. So if the copy of the award was not enclosed in the trial court, Lordship, then proceeding with the judgment and the execution process, it's a futile exercise, Lordship. It is in the eye of law, it is not admitted, Lordship. So today the execution proceedings, they filed for execution proceedings in the trial court, Lordship. But when subsequently on searching out the records and everything, we found out that the copy of because we are the National Highway Authority of India, we were not aware that the copy of the award was not there in the record. Because initially the case was in Shillong, subsequently the case was transferred to Nongpo. Due to the frequent transfers and due to the case records being transferred and everything, we also, being the National Highway, we also lost the track of the case. When on receipt of the notice from the Honorable Court at Nongpo, we again started appearing the cases. Meanwhile, the evidence proceeded. So we did not get chance to cross the witnesses also. Subsequently, the judgment was passed in a haphazard manner without checking the proper process, due process was followed while making the reference. And when the execution case was filed before the Honorable Court at Special Judicial Officer Nongpo, on repeated objections, Lordship, because the judgment holder is the deceased person, and the execution was filed in the name of the company. So it is for us also, it was more confusing, Lordship, because if the execution case was filed, initially they proceeded with the claim petition, they proceeded with the company name. Subsequently, the owner came up, and the proprietor of the company, he came up and he said that he wants to proceed the case in his own capacity, not as a company. So after he proceeded with in his own capacity, the judgment was passed in his capacity. Then subsequently again the execution proceedings, Lordship, the order was passed in the name of the company, Lordship. Now we are in a very dilemma, Lordship.
But you have not, you have not raised all these issues with the.
We have, Lordship. We have, but still, since the execution proceeding is to be completed within 6 months, lower court below has.
Please enlighten me.
Yes, Lordship.
In what manner is the execution to be carried out? Was there any? I think this involves compensation, isn't it? It involves compensation.
Compensation, yes, enhancement of the
for land acquired.
Yes.
Okay.
Yes.
So the land was acquired on your behalf.
Yes, Lordship.
Okay. So the collector has taken all the steps, whatever the case may be.
Whatever the.
Now, those who are interested, or those who are landowners, title holders, whatever, they have been given notice as
as per the process. Yes.
And when the award was was passed by the collector,
Lordship.
so that amount you have already deposited with the collector,
Lordship,
and that amount would be disbursed to the
the award amount was already disbursed.
To the claimants or whatever,
Lordship,
to the landowners.
Yes, Lordship.
That is that step is
that
done.
Step is clear.
Okay. Now, subsequently, some of the landowners or those who have received the compensation, they are not, agreeable to the.
They were not satisfied.
So, not satisfied, they have filed an application under Section 18.
Yes, Lordship.
For reference. So that stage is also there.
That stage reference, still reference.
So, so now reference court, the special judicial officer would take over the case.
Lordship, now here the twist is, when the reference is made, Lordship, the copy of the award should be there with the reference.
That's okay. Let's say there's no copy of the award.
Yes, Lordship.
But still, the matter it was proceeded
Lordship.
Before the special judicial officer.
Lordship.
Isn't it so?
Yes, Lordship.
So at the end of the day, when everything is said and done, the order was passed.
Yes, Lordship.
For enhancement or not to be enhanced.
For
whatever the case.
Yes, Lordship.
So in this case, the order was passed for enhancement.
Enhancement, Lordship.
Okay. Now, now I got it. So as far as enhancement is concerned, now you have to pay.
I have to pay, and for enhancement order, Lordship.
So
now, when the if order is there, Lordship, in some of the proceedings, it so happened also, Lordship, that when the copy of the award.
But you have not filed appeal against the order of enhancement.
No, Lordship. During that time, what happened, Lordship? I already gave my legal opinion, but it takes time, Lordship, because we have to go to MORTH, Ministry of Road Transport.
Okay,
all these processes are there, Lordship. So
when was the order passed by the reference court?
By the reference court, it was 2020, Lordship.
2020.
2020. But Lordship, here the twist is, Lordship, because it is a common judgment, Lordship. So common judgment, when the other party who appeared before this honorable, who came as an appeal to, because they were not satisfied with the enhanced amount also, they came as an appellant before this honorable court. So on perusal of the record, because this is a common judgment.
That is the case that is pending before this
yes,
court.
Lordship.
Okay.
So on perusal of the record of that case, Lordship, it was revealed that there was no award.
But you see, why you cannot come before this court to say that we on perusal there's no award and all those things. That was also noticed by this court and by the parties in the other case.
Lordship.
But it would have been incumbent upon you to go through all those. See, the papers are there. You should have gone through the claim petition. You should have gone through the annexures. You should have gone through your written statement. And also the records, forwarded by the collector. All those things should have been done by you. That much you should do. But
Lordship,
now maybe you have just participated and then
Lordship, we
accepted.
have no Lordship in the execution proceeding. Lordship, in my memo of appeal, Lordship, or in miscellaneous. In the condonation of delay, Lordship, annexure 2, Lordship, the order was passed, Lordship, in my condonation of delay, Lordship, for against the execution order.
Where's annexure 2?
Sorry, Lordship, it is to the stay the proceedings, Lordship, in the another case, another miscase application under order 41, the other miscase, Lordship, for the stay of the proceeding, Lordship. Lordship, in annexure 2, Lordship, page 52, Lordship, the order.
Yes.
Lordship, here it is para 3, Lordship. During the hearing of the execution petition, learned counsel for the claimant submits that claimant Rajkumar Deora represents MS Radha Creations, died on 25/06/2020 after the judgment and decree has been passed. After his death, his son Rohit Kumar Deora, director, filed this petition and of the CPC on behalf of his father holding the execution of the decree. Now, Lordship, in the judgment, Lordship,
I think
Lordship, it is a common judgment, Lordship.
Ms. Prasadi,
Yes, Lordship.
we'll take up this matter at 2.
2. Okay, Lordship.
Because I don't think we'll have time now.
Lordship.
Then, would you, Lordship, can you take it up tomorrow then, Milord? I have some other issues, Milord. If it can be taken up tomorrow, because what's happened is that this was served upon us yesterday. I did not realize they would file it as an unlisted matter.
Because
So I could not.
urgency is there, execution is
Then fine. 2 is fine. 2 is fine.
execution is fixed for today.
Lordship.
Today,
Today, Lordship.
you will not be so
In
much.
case I am not the Milord, yes, actually, I am not really affected by this.
So we'll take it out 2.
2. No.
Second call from supplementary 1.
So, Lordship,
If I recall, in that other case,
yes, Lordship.
you had made a prayer for filing of a cross appeal, isn't
Cross
it?
appeal also, Lordship. In that case also,
This is not related to that.
Lordship, no, Lordship, the judgment is a common judgment, Lordship, but the parties are different, Lordship. I was also under impression that the parties are common because the surnames are same. So that is why, Lordship, we took, we did not prefer appeal because they came up as an appeal. Because the names are Sabita Devda, Rajkumar Devda. So I initially understood as a common person, Lordship, that the two names are similar, Rajkumar Devda and Sabita Devda. So that is why, Lordship, we did not prefer that time appeal, because since Sabita Devda has come as an appellant in, before this honorable court, so I was under impression that Rajkumar Devda is related, and Rajkumar Devda has also expired, so she has represented Rajkumar Devda. Subsequently on receiving the copy of the execution petition, I understood that it is the two cases are different, the Sabita Devda and Rajkumar Devda.
So this is different.
This is different, but Lordship, the if I draw
But
Lordship
the
attention,
impugned judgment is the same.
impugned judgment is same, but two persons are different. But here in annexure 1, Lordship, page number 12, Lordship, in my petition, it is stated that Rajkumar Devda, the degree holder, Lordship.
See, Miss Varsaji,
Yes, Lordship.
if I can understand correctly, okay, you have filed this appeal with prayer for stay.
Stay, Lordship.
But in the meantime, you have also filed an application for condonation.
Condonation, Lordship.
Now, without disposing of the condonation application,
Lordship.
the main application cannot be taken up.
No, Lordship.
So the question of stay will not come.
Lordship.
You understand?
Lordship.
So how do you overcome that?
The Lordship, then give us, because the other case is listed on 3rd of July, Lordship. So I'll take a dusty service to the Rajkumar Devda and let the matter come up on 3rd July. We have already intimated the lower court below that the matter, since it has come as a supplementary cause list, so we have intimated the lower court below that the matter is listed before this bench and as a supplementary cause list. If we don't get stay or any other order, we will let the court know, lower court below. So Lordship, it may be because Lordship, the lower court, I understand the lower court is also under compulsion that within 6 months has to dispose of the execution. So Lordship, unless and until they are also, it is the order of the court is incumbent on them. And if we don't get stay here, Lordship, if the judgment itself is a defective judgment, Lordship, and then execution will not proceed.
You see, the fact you are to be blamed. You see, you should have been careful enough to go through the impugned judgment, see how it affects you. Then you take steps, file.
Lordship, here,
first appeal here or whatever. You have not done that. Now this delay is 1,842 days.
Lordship.
That also will be very hard for you to explain.
Lordship, in the middle it was COVID, Lordship.
Okay, COVID period.
COVID period
that can be eliminated, no?
Yes, Lordship. Apart from
even if we take into account COVID period,
Lordship,
it will still be about more than 1,000.
Lordship, Lordship, I was under impression because of the Sabita Devda and Rajkumar Devda are
true. You see, now your impression will not matter.
Lordship.
It's the law that would speak for itself.
Lordship.
So, okay. Heard Miss Chari that you are the standing counsel?
Empaneled lawyer, Lordship. Empaneled lawyer.
Okay. Learned counsel for the. You see, I've always said, when you file application for condonation,
Lordship.
you are not the appellant. You see, you are the applicant.
Lordship.
Until and unless the appeal is admitted, then you become the appellant.
Lordship.
But here you have written appellant responded in claim petition. Who has for the counsel for the representing the project director, National Highway Authority of India, who has submitted that an appeal has been preferred. Appeal is proposed to be filed before this court against where is the impugned judgment?
Lordship.
Judgment and order dated
1103, Lordship.
1102 or 03?
03, Lordship. In the CIA, in the certified copy, it is written as 02, but in the order sheet, it is 03, Lordship.
Kunung Toko? (1103/2022).
2020.
2020 passed in under bracket ref REF LA case number 109 of 2015. However, there is
Lordship, it is 108 of 2015. Lordship, 109 is Sabita Deora.
108.
108.
However, the appeal could not be filed in time, and as such, this application can you file a pass in this case more. This application is preferred with a prayer for condonation of delay in filing the said appeal, the period of delay being 1842 days. The learned counsel has submitted that notice may be allowed to be issued upon the respondent number 3 herein by Dusty. Next, Miss Ailungwa Larat G has accepted notice on behalf of the respondent number 1 and 2 respectively. As such, no formal notice is required to be issued upon such respondents. You've received a copy of the...
Yes, Your Lordship, we received yesterday, Your Lordship.
Accordingly, as prayed for, let steps be taken for issuance of notice. The same to be processed through the normal course as well as by Dusty service. As prayed for, list this matter on. 37. Third.
Third.
Obliged lordship.
Ajay, Ajay.